Hello, everybody.
Next cases the court is going to take up. State of North Dakota versus David Allen Compson. 02-2024 CR320. 02-2024 CR324. 02-2024 CR325. Ms. Duffy appears on behalf of the state on all three cases. Ms. Calling appears on behalf of the defendant on all three cases. The defendant appears personally in court. Good morning, sir.
Good morning.
Ms. Calling, what's the plan today in these cases?
Your Honor, we're going to move to withdraw our not guilty pleas and enter guilty pleas on all of these cases.
All right. And to all of the original charges?
Yes, Your Honor.
Okay, so we're going to take these one at a time, and I'll start with the oldest first. And then we'll, just so you understand, Mr. Compson, and so the record is clear, there's some questions that I'm going to ask at the beginning that apply to all of your cases. And then I'm going to ask you about each case individually. And then we'll talk about sentencing again together. Does that make sense?
Yes, Your Honor.
All right. So were you present in court today and at earlier times when your rights were read to you?
Yes, Your Honor.
Do you understand your rights?
Yes, Your Honor.
Do you have any questions about your rights?
No, Your Honor.
You understand that you have the right to plead guilty or not guilty and have a trial?
Yes, Your Honor. I understand.
Okay. And at one point in your case, the court asked for an evaluation from the state hospital to tell me whether or not you were fit to proceed. Do you remember that?
Yes, Your Honor.
And the court received reports saying that you were fit to proceed in all of these cases. Has anything changed since that fitness to proceed report was received by the court?
Not that I know of, Your Honor.
So do you have any questions about what's going on today?
No, Your Honor.
Are you under the influence of any substance or any alcohol, or have you done anything that affects your ability to reason and understand?
No, Your Honor.
Do you feel comfortable moving forward today, that you understand everything that's going on?
Yes, Your Honor.
All right. If at any time you have any questions, I need you to stop me and say, hey, Judge, can I have a moment to speak with Ms. Calling, okay?
Okay, Your Honor.
All right. Do you understand that in all three of these cases, by pleading guilty, you're waiving all the rights that were read to you before?
Yes, Your Honor.
Do you understand that in these cases, you do have the right to a trial, to either a judge or to a jury, in file 325, those are felonies, so that would be a jury of 12. In file 324, that's a misdemeanor, so you'd have a right to a jury of 6 in that case. In file 320, that's a felony, so you'd have the right to a 12-person jury. You understand that all jurors, whether it's a misdemeanor or a felony, and whether it's a jury of 6 or 12, depending on whether it's a felony or a misdemeanor,
Yes, Your Honor.
that all jurors would have to agree that you're guilty before you could be found guilty.
Yes, Your Honor.
And you're waiving that right for all of the jurors to unanimously find you guilty.
Yes, Your Honor.
To understand that by pleading guilty, you're waiving the presumption of innocence.
Yes, Your Honor.
To understand that you're waiving in each of these cases the requirement that the state prove you guilty beyond a reasonable doubt.
Yes, Your Honor.
To understand that you're waiving the right to confront and cross-examine witnesses against you.
Yes, Your Honor.
To understand that you're waiving your right to remain silent.
Yes, Your Honor.
To understand that you're waiving the right to testify for yourself.
Yes, Your Honor.
To understand that in each of these cases, you have the right to present witnesses and evidence on your behalf and to use the court subpoena power to force those witnesses to appear, and that by pleading guilty, you're waiving those rights.
Yes, Your Honor.
To understand that by pleading guilty, you're waiving all of the defenses that you could have had.
Yes, Your Honor.
To understand that you're waiving any and all non-jurisdictional defects in the case if there are any.
Yes, Your Honor.
To understand that by pleading guilty, if you do so like you're doing today, not in a written form and not with reserving your right to appeal, that you're limiting your ability to appeal from any of these cases by pleading guilty.
Yes, Your Honor.
Do you still want to plead guilty in all three of these
Yes, Your Honor,
cases?
still want to plead guilty.
Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to plead guilty?
No, Your Honor.
Has anyone told you that you have to plead guilty?
I do want to plead guilty so I can get this court stuff taken care of.
Okay, has anyone told you that you have to, that you have no other choice?
No, Your Honor.
Okay. Are you pleading guilty because this is what you voluntarily want to do?
Yes, Your Honor.
And are you comfortable that you know what's going on and you know what you're doing here?
Yes, Your Honor.
And have you had enough time to speak with Ms. Calling about your case?
Yes, Your Honor.
And are you pleading guilty after having an intelligent conversation with Ms. Calling and you're making an intelligent choice based on the advice of counsel?
Yeah, I was talking to her and I told her decide to plead the guilty for everything
Okay.
and then serve the rest of the days in the jail so this court stuff can get taken care of.
All right. Do you need any more time to speak with Ms. Calling about your rights, any defenses, your pleas today, and the potential for sentencing?
No, Your Honor.
Are you pleading guilty because there's a plea agreement in place?
No.
All right, so there is no plea agreement in place. Is that your understanding, Mr. Thompson?
Yes, Your Honor.
And you might have heard a sentencing recommendation from the prosecutor. Is that right?
Yes, Your Honor.
And you understand that that is a recommendation. Ms. Duffy will make a recommendation to me, and Ms. Calling will make a recommendation to me, and then I'll ask you for your recommendation. But ultimately, I'm going to decide what the appropriate punishment is, and it might be different than what Ms. Duffy recommends. It might be different than what Ms. Calling recommends, and it might be different than what you recommend. Do you understand that?
Yes, Your Honor.
And you understand that if I do something different than what you expect, that wouldn't be the basis to say, well, that's not what I want a trial. You wouldn't be allowed to withdraw your plea and have a trial if you don't like what I did at sentencing. Do you understand that?
Yes, Your Honor.
Do you still want to plead guilty knowing that?
Yes, Your Honor.
All right. Were you present in court at a previous time when the nature of the charges were explained to you?
Yes, Your Honor.
Do you recall what the maximum penalties are?
I know there was 3 of them, but I couldn't remember.
All right. So we'll talk about those maximum penalties as we walk through your charges.
Okay.
And we'll talk about any minimum mandatory penalties and court fees. Do you remember restitution being a potential for the court?
Yeah, I remember that, restitutions and.
All right. And how about the potential for immigration consequences if you're not a United States citizen?
He's a U.S. citizen, Your Honor.
Yep, I'm a U.S.
All right. And do you recall that there might be other consequences that happen? We call those collateral consequences, but I'm not required to explain those to you.
Oh, yes, Your Honor.
All right. So we'll walk through each of those cases individually now. I'm going to take up file 324 first because it's the B misdemeanor. So in that case, sir, you're charged with a Class B misdemeanor disorderly conduct. The state alleged that you engaged in a violent, tumultuous, or threatening behavior in reckless disregard of the fact that Ruth Peck was harassed, annoyed, or alarmed, you engaged in violent or threatening behavior on or about November 20, 2024. To that charge, how do you plead? Guilty or not guilty?
Yeah, guilty.
You plead guilty to that count?
Yeah, for that one.
All right. And a Class B misdemeanor has a maximum penalty of 30 days in jail, a fine of up to $1,500 or both. It has court fees associated with it, totaling $250. It does not have any minimum mandatory penalties except for the requirement that you submit fingerprints for law enforcement databases. If your conduct caused any loss or financial harm to another person, the court can order restitution. If you're not a U.S. citizen, it can have immigration consequences, and it sounds like that doesn't apply to you. And it can have collateral consequences for you. Do you understand that, sir?
Yes, Your Honor.
Do you still want to plead guilty to that count?
Yes, Your Honor.
Ms. Duffy, a brief factual basis.
In this case, Your Honor, back on November 20th, 2024, the sheriff's office was dispatched to the courthouse here in Valley City. On a report, they initially made contact with my office, and we had informed them to go check on the clerk's office. They checked in with the clerk's office and spoke with one of the deputy clerks, Ruth Peck. In talking with her, they learned that Mr. Thompson had entered the clerk's office. Ms. Peck had approached the window, and when speaking with him, she asked him for his name. At that point, he became angry and punched the protective window in between him and Ms. Peck. Ms. Peck was harassed or alarmed or annoyed by Mr. Thompson's behavior.
Mr. Thompson, is that what happened?
That is correct, Your Honor.
Or is there anything else that you want to tell me with respect to the facts of the offense?
That's exactly what had happened because I hate when clerk of courts, they ask what my name is, but then when I ask what their name is, like if I talked to them like a long time ago, they don't want to give me their name, and then that's when Tanya Duffy was right on that part. That's when I got mad at the lady at the clerk of court, and that's when I punched that glass window part.
Okay.
Because I was complaining against someone.
All right. Ms. Calling, when this case was first charged, I didn't realize who the victim is, and that poses some concern for me. Are you asking that I recuse on this case because I work in this courthouse closely with Ms. Peck?
No.
All right. And Ms. Duffy, any conflict of interest on your behalf that you asked that I recuse on this case?
No, Your Honor.
Mr. Thompson, do you understand what I asked the attorneys?
Yes, Your Honor.
Do you want me to send this to a different judge to sentence you on this case?
If you want to, Your Honor.
Well, it's up to you.
Your Honor, if I may, he's already maxed out his sentence in this case. So I think that might help things along.
All right. And so, Mr. Thompson, are you asking that a different judge sentence you? Sounds like your attorney doesn't think that's necessary, but I'm leaving it to you, sir.
Sure.
We don't need a different judge.
No.
Judge Thornton can
No.
handle it. Yeah.
No, Your Honor.
All right. The court accepts the guilty plea and finds that the same is freely, knowingly, and voluntarily and intelligently entered. The court finds an adequate factual basis to support the plea to that charge. Now we're going to move to a different file. We'll move to file 320. In that case, sir, the state charges you with terrorizing. It is a Class C felony. The state alleges on or about November 14, 2024 in Barnes County that with the intent to place an individual with the initials KJ in fear for her or another's fear, or in reckless disregard of causing such fear, that you threaten to commit an act of violence by using a baseball bat on people to crack their heads open and breaking windows at the city court. To that count, how do you plead, guilty or not guilty?
Yeah, guilty for that one.
Okay. And that, sir, is a Class C felony. Class C felonies have a maximum penalty of 5 years in prison, a fine of up to $10,000 or both. The state has not alleged a minimum mandatory penalty except the requirement that you submit a DNA sample for inclusion in law enforcement's databases. Fingerprinting also is something that needs to happen if you're convicted of that offense. The state has not alleged any other minimum mandatory penalties. Court fees for that type of case total $525. If your conduct caused any loss or financial harm to another person, the court can order restitution. If you're not a U.S. citizen, this can have immigration consequences. It might also have other collateral consequences. Do you understand all of that, sir?
Yes, Your Honor.
And do you still want to plead guilty?
Yes, Your Honor.
Has anyone threatened you, forced you, or coerced you, or made any promises in order to get you to plead
No,
guilty?
Your Honor.
Is this what you freely, knowingly, and voluntarily and intelligently want to do?
Yeah, I do want to plead that because I had no right doing that, but I was getting frustrated with the law enforcement because they would pick on me and made threats to damage one of our vehicles, and that got me mad and angry. That's why I had said those threatenings of the baseball bat type thing.
Okay. But do you understand that you have the right to plead guilty or you have the right to plead not guilty to that offense?
Yes, Your Honor.
Okay. Do you need more time to speak with Ms. Calling about your rights, any potential defenses, your plea and sentencing?
No, Your Honor.
Are you pleading guilty because there's a plea agreement in this case?
No,
It's
Your Honor.
it's a sentencing recommendation, as your understanding, sir.
Yes, Your Honor.
And again, you understand that I'm free to do something different than what's being recommended?
Yes, Your Honor.
Okay. And for this, I just explained the maximum and minimum possible penalties and the nature of the charge. And your plea to that is guilty, sir?
Yes, Your Honor.
Ms. Duffy, a factual basis?
In this case, back on November 14th, 2024, the police department had received a note from the defendant. Within that note, the essence of it was Mr. Compton was upset, as he had just mentioned, with law enforcement, and he had threatened to use a baseball bat on people and crack their expletive heads open and break the expletive windows at the city court. The note goes on to talk about if they don't leave him alone, that's what he's going to do. The person who had received this, her initials are KJ. She works at the police department. The note that he had left had caused her fear from the way that he had approached and the content of the note in itself.
Sir, is that basically what happened?
Yes, Your Honor.
All right. The court accepts the guilty plea to that charge and finds the same freely, knowingly, and voluntarily and intelligently entered. The court finds an adequate factual basis to support the plea to that count of terrorizing. Moving on to the last file ending 325. Ms. Duffy, there's a confidential information form related to an amended criminal information, but I don't see the amended criminal information. Was one never filed?
There shouldn't be an amended one, I don't believe, on this. I can check my notes, but I don't think anything was amended in the 325 file.
Okay, well, what I was looking at is record 7, or maybe that was just mislabeled as an amended confidential information, not an amended criminal information. Okay. So, sir, in count 1 of the criminal information, the state alleges that on or about November 26, 2024 in Barnes County, that you committed the offense of simple assault by willfully causing bodily injury to a police officer or a correctional institution employee acting in their official capacity, which you knew to be a fact, in that you inflicted bodily injury on Trooper Dustin Pattengale, an officer working in the course of his duties, which you knew to be a fact. That's charged as a Class C felony. Actually, all of these offenses are charged as Class C felonies, so we'll talk about all of the maximum and minimum penalties together. Count 2, the state alleges that on or about that same date that you committed simple assault on a police officer by inflicting bodily injury on Officer Zach Gruba, an officer working in the course of his duties, which you knew to be a fact. That offense, count 2, is also a Class C felony. And count 3, the state alleges that on or about that same date, November 26, 2024 in Barnes County, that you committed the offense of preventing arrest, in that while you were being placed under arrest for a felony, that you employed means justifying or requiring substantial force to effect the arrest. That also is charged as a Class C felony. And so for counts 1, 2, and 3, all of them are Class C felonies. They all have the same maximum penalty, 5 years in prison, a fine of up to $10,000 or both. The state has not alleged any minimum mandatory penalties for these offenses except that you submit a DNA sample and fingerprinting. Court fees for this type of offense or these types of offenses total $525. The court has the ability to impose restitution if your conduct caused any financial harm to anybody. If you're not a U.S. citizen, these types of offenses can carry with them significant immigration consequences. They might also carry significant collateral consequences. Understand all of that, sir?
Yes, Your Honor.
So count 1, simple assault on a police officer, Dustin Pattengale, trooper with the North Dakota Highway Patrol. To that count, how do you plead? Guilty or not guilty?
Yep, guilty, Your Honor.
Count 2, simple assault on a police officer, Valley City Police Officer, Officer Zach Gruba. To that count, how do you plead? Guilty or not guilty?
Yep, guilty.
Count 3, C felony preventing arrest. To that count, how do you plead? Guilty or not guilty?
Yep, guilty.
Ms. Duffy, a brief factual basis, please.
In this case, Your Honor, back on November 26th, 2024, the defendant had an outstanding felony arrest warrant for the terrorizing case that the court just went through. Deputy Morton had given information to Trooper Pattengale that about this warrant and how they were looking for a particular vehicle that they believe Mr. Thompson might be in. Trooper Pattengale eventually located that vehicle up at Love's gas station here in Valley City in Barnes County. Trooper Pattengale made contact with Mr. Thompson's brother, Jared Jorgensen, who had stated that Mr. Thompson was in the vehicle and he was in the passenger seat. Law enforcement eventually approached the vehicle. Mr. Thompson was visibly agitated and did not want to get out of the vehicle. He eventually began to unbuckle his seatbelt and got out. Officer Gruba and Trooper Pattengale then stepped towards Thompson. At that point, the defendant had turned and began striking at both Officer Gruba and Trooper Pattengale using closed fists. Trooper Pattengale was struck in the lower lip. They grabbed a hold of the defendant and he was pulled to the ground. During this altercation, the trooper had sustained cuts on his hand. Officer Gruba had sustained an injury to his back. There was a substantial amount of force that was necessary through the course of this arrest to place the defendant under arrest. Through the course of this, both Officer Gruba and Trooper Pattengale were working in the course of their duties, which the defendant knew to be a fact.
They uniformed?
They were both uniformed, yes.
All right. Sir, is that essentially what happened?
Yes, Your Honor.
Do you have anything else that you want to tell me about the facts?
Yeah, when they told me to get out of the vehicle, heard that that I had a warrant out. I was getting arrested from the city court because I'm making like payments to the city court, and that's where I thought that they had a warrant out, like when they were at the parking lot at Love's. But here it was from the threatening and terrorizing stuff, but that's true.
Okay, so do you agree that when they asked you to get out, eventually you got out, but then you were struggling and you got into a fight with the trooper and the Valley City police officer? In the course of that fight, both of them were injured?
Yes, Your Honor.
And you knew they were cops, right?
Yes, Your Honor.
Okay. Anything else you want to tell me about the facts? Is there anything else you want to tell me about the facts, sir?
No, that's all, Your Honor.
All right. I am going to accept the guilty pleas to counts 1, 2, and 3, find the same are freely, knowingly, and voluntarily and intelligently entered. The court finds an adequate factual basis to support counts 1, 2, and 3. I'm going to hear, at this point, I've taken guilty pleas in all 3 files. I've taken and accepted guilty pleas in all 3 files. I find an adequate factual basis. Mr. Thompson has previously been found fit to proceed. The court finds that he is interacting with the court in a rational, reasoned way. The court continues to find him fit to proceed in light of the presumption of fitness, the report that has been filed into each of these cases by the North Dakota State Hospital, and the court's own observations of Mr. Thompson in these proceedings. And so what I'm going to hear now is I'm going to hear about your criminal history from Ms. Duffy, and then I'm going to hear Ms. Duffy's sentencing recommendation, and then I'm going to hear your attorney's sentencing recommendation. And then lastly, sir, I'm going to give you an opportunity to tell me anything you want me to know before I'm post-sentence, and then I'll sentence you, okay?
Okay, Your Honor.
All right. Ms. Duffy, first, criminal history.
In this case, Your Honor, Mr. Thompson does have some criminal history. Spans back starting in 2000 for some NSF stuffs. There is false information, some harassment in 2006, disorderly conducts in 2009, as well as disorderlies in 2016 and 18. In 2019, there was a terrorizing adult victim case that he pled guilty to. There was a simple assault of a peace officer back in 2020, as well as an attempted violation of an order prohibiting contact. There was criminal mischief out of the city of Valley City from October of 2024, and then that brings us to these 3 cases. The October 2024 case was in Valley City, where he got upset at somebody at the nearly near the thrift store and kicked their door open and broke the door. For a sentencing recommendation, I'd ask the court to sentence him to 18 months DOC, first to serve 90 days in jail, credit for 61 days actual days served, credit for 10 additional days of good time. So the total number would be 71. A year of supervised probation with the conditions found in Appendix A. If I didn't mention this, I'm just starting at 320 or CR 320. I would ask the court to waive the administrative and facility fees. He is indigent to my understanding, and I believe he also receives either SSI or SSDI. I would ask the court to impose a $25 victim witness fee on CR 320. Moving to CR 324, 30 days of jail, credit for 30, no probation, and I'd ask the court to waive the admin and facility fee and impose the victim witness fee. On CR 325, 18 months DOC, first to serve 90, credit for 61 actual, 10 plus 10 days of good time, so a total of 71. Another year or a year of supervised probation with conditions found in Appendix A. I would again ask the court to waive the admin and facility fee and impose the victim witness fee. So those total fees the state would ask for is $75. He does have $400 worth of bond posted. So I'd ask that that be applied and the remainder to be refunded to the remitter. On CR 325 for counts 2 and 3, just the same 18 months DOC and supervised probation as outlined in count 1.
All right. Ms. Colling.
Your Honor, essentially what we're asking for in the felony cases is a 360 days to the Barnes County Correctional Center with all but time served suspended. So essentially we're asking for a misdemeanor by disposition. I understand that's probably a lot to ask, but it seems to me that he was going through a very rough patch because all of this seemed to happen within about a 2-week period of time. So I don't know what was going on with him. We thought he had maybe some issues. That's why we did the evaluation at the state hospital. But since he's been on probation while he failed to appear in court, there's been no additional new charges. So to me, that's promising. So we would ask for 360 days, Barnes County Correctional Center with all but 71 days suspended, credit for the 71 days already served, 1 year of supervised probation on Appendix A terms and conditions that this court feels are appropriate. We agree with the waiver of the mandatory fees except for the $25 victim witness fee in each of the cases or files. My client is financially indigent. He survives basically on, is it Social Security disability or just SSI?
If SSI and SSDI, that's my mom's money.
Okay. He does live with his brother and his brother's husband here in Valley City. He does have an elderly dog that he is responsible for. And with his brother in his living situation, they split up the household chores and they also split up the bills. So, you know, they are in need of my client's financial contribution to the household finances. So we believe that that would be an appropriate sentence for the felony cases. And then for the misdemeanor, we would just ask for a 30-day straight time sentence, credit for 30 days already served.
All right. Mr. Thompson, is there anything that you want to tell me before I impose sentence?
No, Your Honor.
All right. I'm going to start with file 324, the B misdemeanor. The courts considered the general purposes of the criminal code and North Dakota Century Code section 12.10102. The courts considered the sentencing factors in 12.13204. The courts considered the amount of jail credit the defendant has on this file already. And so in this case, the maximum penalty is 30 days in jail. The defendant has more than 30 days in jail credit actual. The court's sentences as follows: 30 days in the custody of the Barnes County Sheriff to be served at the Barnes County Correctional Center. Credit for 30 days actual, concurrent with file ending 325 and 320. Fees, all of the fees waived. Moving on to file 320. This is the city court case. The terrorizing involving city court sentence will be as follows: 18 months in the Department of Corrections and Rehabilitation. First to serve 71 days, credit 71 days. And that's first to serve 71 days in the Barnes County Correctional Center, credit for 71, of which 61 is actual, 10 days good time, balance suspended for a period of 2 years, 2 years supervised probation, fees waived, standard conditions of Appendix A, special condition, the defendant to obtain a diagnostic assessment from a regional human service center and follow through with any treatment recommendations from the regional human service center while on probation, concurrent with file 325 and 324. Moving to file 325, count 1, 18 months, Department of Corrections and Rehabilitation, first served 71 days, Barnes County Correctional Center, 61 days actual time credit, 10 days good time credit, sentence reduction credit authorized by law, 2 years supervised probation, balance suspended for 2 years, fees waived, special condition diagnostic assessment from a regional human service center, follow through with any treatment recommendations from the regional human service center, concurrent with 324, concurrent with 320, same sentence on 1, 2, and 3. Ms. Duffy, Trooper Pattengale, and Officer Gruba are not asking for restitution, correct?
Correct, Your Honor.
0 restitution, and no physical damage was noted or any loss or financial or pecuniary harm in the other 2 files, correct?
That's correct.
All right. So no restitution in any of the cases. I'm waiving all fines and fees. The $400 bond will be refunded to the bond remitter due to the defendant's, frankly, extreme indigency. That money will come back. All sentence reduction credit authorized by law. Again, 10 days good time credit applicable in the felony counts. 71 days total on all the felony counts. So what that means, Mr. Thompson, is I'm not putting you in jail any further because I don't think jail is going to accomplish any criminogenic goal or purpose. But I am putting you on probation for a longer period of time.
Okay, Your Honor.
And as a condition of probation, I'm requiring you to get another evaluation from a regional human service center. So that's probably South Central Human Service Center. They're based in Jamestown, but they have a satellite office in Valley City. And you need to follow through with any treatment recommendations from them, because I think that your mental health concerns, and there are some, affect your ability to function in society, and I'd rather have those treated, and I just don't think a jail is going to treat those for you. But you do have to follow through with any recommendations that your evaluator provides. And so if that means medication, if that means anger management counseling, if that means cognitive restructuring, whatever that means, whatever they recommend, you need to follow as a condition of probation. If you don't, state can ask the court to revoke your probation and resentence you up to 5 years on each of those counts and send you to prison. I'd rather not do that, Mr. Thompson. I'd rather get you the help that you need so I don't see you back in my courtroom again, okay?
Okay, Your Honor.
Do you have any questions about what my sentence is?
Yeah, when you mentioned about the South Central, there's no trespassing on the satellite one. So I would have to go to the Jamestown office for that South Central.
Okay, well, they can figure that out.
Okay.
They're the regional human service provider, and so that needs to be accomplished somehow. And your
Okay.
probation officer can help you with that, okay?
Okay.
So if you haven't had your DNA sample taken or your fingerprints taken, you'll need to do that within 7 days. And if you have any questions, you'll need to report to probation within 24 hours, sir. So you should do that today if you can.
Okay.
All right. Do you have any other questions?
No questions, Your Honor.
Ms. Duffy, did I miss anything?
No, Your Honor.
Ms. Calling, did I miss anything?
Do you have a little card with the contact number or contact information for on probation? Okay,
Yeah.
we'll get
So
you that contact information so you can call them today.
Ms. Calling will get you that card so you can report to probation today.
Okay.
And you need to do that within 24 hours, okay?
Okay.
All right. With that, we're adjourned in these cases. Have a good day and good luck to you, sir.
Yep. Thanks, Your Honor.
All right.
Thanks.
Thank you, Your Honor.
With that, we're adjourned.
Be safe, be well, sleep sweet, and much love.